The final case we will hear today is People versus Travis Sammons.
Good afternoon, Your Honors. Gaten Javillarash on behalf of Mr. Sammons. I would like to reserve 2 to 3 minutes of rebuttal time, if I may. May it please the Court. Intercepting 16-year-old DeWant Jones in the hallway and asking him if he recognized the two defendants as they sat in interrogation rooms was an improper interrogation procedure, and the identification that was supposedly extracted by Detective Rivard in using that procedure should have been suppressed. We have decades of precedent and volumes of scientific studies, many of which were laid out in the amicus brief of the Innocence Project, establishing that show-up procedures like this are inherently suggestive and should only be used when it is necessary to do so. Law enforcement in this case has offered no explanation for why they needed to conduct a show-up in this case as opposed to conducting a proper lineup. Under Manson versus Brathwaite, that alone makes this show-up procedure improper, contrary to what the Court of Appeals has said. Because the procedure was unnecessarily suggestive, the trial court and the Court of Appeals were required to analyze all of the bigger factors, not just the one factor that favored law enforcement. Applying those factors means taking into account that Jones only saw the shooting for a fleeting moment from across the road as he sat in the back seat of a moving vehicle just before it sped away, that he was paying more attention, according to him, to the driver of the vehicle than he was to the shooter, taking into account the mismatch between the description that Jones gave of the shooter and the license plate, and my client and the license plate on the vehicle that he was apprehended in. The fact that there was no documentation taken of this show-up procedure to establish how certain Mr. Jones was, what exactly the conversation was. How did he say it when he said, supposedly, that he had recognized my client? The influential age of the witness in this case. And last but not least, the fact that he denies ever making the identification. All of those factors together should lead the court to conclude that this undocumented show-up procedure resulted in a substantial likelihood of misidentification, was fundamentally unfair, and should have been suppressed. There is no way that the prosecution can show, beyond a reasonable doubt, that the error of introducing this admission testimony did not affect the outcome here. Judge Jackson, for the first time in his 15 years on the bench, entered a directed verdict in favor of the co-defendant Ramsey, only because there was no identification testimony introduced against him. That is the only meaningful difference between the evidence introduced against Ramsey and the evidence introduced against my client. And because that identification testimony should have been suppressed, this court should reverse.
Counsel, what's your response to the argument that, given that the witness identified only one and not both of the people in custody, that actually makes his identification of your client more reliable?
Well, first of all, it doesn't make it a proper lineup. That's for sure.
I think that, right.
Okay,
but does it make it more reliable?
I don't think it does at all. I don't think there's any surprise that he would not have, first of all, chosen Mr. Ramsey as a driver when he described the driver as weighing 320 pounds, and Mr. Ramsey weighs 150. And secondly, he did testify that he thought that Mr. Sammons had some features that were similar to the shooter. Perhaps Mr. Ramsey did not. But that doesn't take away the fact that this was a suggestive procedure and that he was guessing. And if you look at the circumstances in which the factors that we're supposed to be applying here, it's really hard to think that he would have been able to take a good look or did take a good look at the shooter. I mean, he specifically said that he didn't. He said he was paying attention to the driver. So I really don't think that it lends much at all, if anything, to the reliability factors. The whole idea of a misidentification is that the witness thinks they are relying on their memory. So to say that he must have been relying on his memory as opposed to just going with what the investigator was suggesting, I think is misinformed. I think the whole point of not allowing law enforcement to do this is that it corrupts the identification so that we wind up not being able to actually test to see if he did have a reliable memory to begin with. So that's why we wind up having to apply these factors.
The fourth biggest factor is the level of certainty demonstrated at the confrontation, not the level of certainty demonstrated at trial. I really don't know. Perhaps you have some better sense of it, what happened between the time of the identification and the time of Jones's testimony. But is it relevant to know that he chose not to testify at that point when there's at least some significant evidence that he did purport to identify?
The only evidence that we have is, of course, that of Detective Rivard. And that's what makes this procedure fundamentally unfair, in my view, is that this procedure was specifically arranged from on high by the prosecutor's office. They asked for permission to do this, and they knew exactly what they were doing when they did it. They arranged a procedure where they were pitting the word of Detective Rivard against a 16-year-old. And that is fundamentally unfair to Mr. Sammons, who had no control over this process. And once it's done, once the toothpaste's out of the tube, it's out of the tube. You can't put it back in these situations. Does that answer your question, Your Honor?
Well, it does, although I think the Chief Justice makes an interesting surmise that the suggestiveness of the identification, which is kind of a threshold inquiry that the court makes in these contexts, is at least called into question, significant question, by the fact that Jones identified one of the alleged people in the car and didn't identify the other one.
I think all that means is that it wasn't so corrupting that he was willing to identify both of them or willing to identify Ramsey instead of Mr. Sammons. It doesn't mean that it wasn't corrupting, that's for sure. And it doesn't tell, and you still have to go through and look at all the other factors, which neither of the courts did. And that baffles me. They enumerated them, but they didn't actually go through them and consider them. The only one that they mentioned was the one that favored law enforcement in this case. I do want to bring to the court's attention that there is some work to be done, I think, on Michigan's jurisprudence in this case, and I hope the court will take the opportunity to do it here. If you contrast what the court said in Kurlchek with what the U.S. Supreme Court said in Perry, they cannot be reconciled. And I think that this is a perfect case in which to fix that problem. I will quote from you. Here's the quote from Kurlchek that I think is problematic. And it says, "A suggestive lineup is improper only if, under the totality of circumstances, there is substantial likelihood of misidentification." Of course, you know the totality of the circumstances test means going through the reliability factors and then weighing those against, is that overwhelming the corruptive effect of the improper procedure? But under Perry, the court says the due process check for reliability comes into play only after the defendant establishes improper police conduct. The propriety of the police conduct doesn't depend on the reliability of the witness. It's either proper or it's not. It's the reliability of the witness that serves as that overcomes the weight of the improper police conduct. That's the judicial screen that we apply instead of a per se rule. So I would invite the court to correct that problem that's been created by a certain misstatement in the law in Kurlchek. have to, the only factor that they looked at was the freshness of his memory, of Mr. Jones's memory when he got to the station house. That really doesn't help at all if you don't know how good his vantage point was in the first place. If you don't know how good of an opportunity he had to actually view the crime in the first place, what does it matter how fresh his memory is? And that's why they have to go through all of the factors. They have to look at the fact that he did not really have a good chance to view the crime when it happened, that he wasn't actually paying attention to the one that he supposedly identified later, and that his descriptions did not match the suspects that they picked up later. Unless the court has any further questions, I will reserve 2 to 3 minutes of time for rebuttal.
You may.
Good afternoon, Your Honors. May it please the Court, Carmen Fillmore from the Saginaw County Prosecuting Attorney's Office. I have the privilege of representing the people today. I think I'd like to start by clarifying what we are and are not arguing here. I am not standing before you today saying that the show-up identification procedure used here was not suggestive in any way, shape, or form. Rather, I believe that the relevant inquiry is not whether the identification procedure is suggestive at all, but rather whether it is unduly suggestive in light of the circumstances surrounding the identification itself. As Krolchak states, the defendant must show that the pretrial identification procedure was so suggestive in light of the totality of the circumstances that it led to a substantial likelihood of misidentification. I am simply arguing that this case does not rise to that level. I think it's important to note that a suggestive identification procedure speaks specifically to the weight of the testimony, not the admissibility itself. So the fact that a procedure may be suggestive does not necessarily render it constitutionally defective, and it does not necessarily mean that the evidence is not admissible at all at trial. I think the bottom line here is that regardless, the question of reliability is a question for the jury to decide. It's a question of fact. And I think I cited Watkins versus Souders for that proposition in my brief. It's the United States Supreme Court case 449 U.S. 341 at 347. And I'd quote from that case. It says, "Indeed, the only duty of a jury in cases in which identification evidence has been admitted will often be to assess the reliability of that evidence." So I think that speaks to our final point then, is that we believe that even if this evidence was improperly admitted at trial, that it is harmless beyond a reasonable doubt. Here, the jury was free to believe Jones or Detective Rivard regarding this testimony. And I believe that if the jurors were not convinced by the other evidence identifying the defendant and placing him at the scene of the crime, then they would not have been moved by the identification testimony of Jones, which was discredited on cross-examination. So at this time, I would answer any questions that the court may
Isn't
have.
that sort of an impermissible catch-22 for a defendant? That if you say, well, the identification was reliable, therefore it's admissible, but if it's so unreliable, then no jury could have believed it. I mean, they're going to lose under either standard. I mean, how do you square those?
Well, I think here we are saying that the identification itself was reliable, right? And
But you're saying it's harmless because the jury probably would have thought it was so unreliable. Like, it wouldn't have made a difference if it was unreliable.
Right, so we're saying that it wouldn't have mattered one way or another, because if it was reliable, if it was unreliable, then it would be up to the jury to make that determination, to say that the identification itself was not reliable, they will not consider it, and yet they would still convict the defendant in this case. That's exactly what they did with co-defendant Ramsey.
So are you saying by saying reliability is a question for the jury, then, that even if it's suggestive and it's unnecessary, it automatically goes to the jury to determine whether it's reliable or not? I mean, that the jury gets to believe it or disbelieve it? I mean, that's what the case law suggests is the proper way to handle that?
Well, I think, yes, Your Honor, I think it speaks to the prejudice in terms of whether or not the jury believes the identification testimony, right? So if they feel that the identification itself was not reliable and they did not believe that witness, in this case, they still convicted either way. So I'm saying that it doesn't matter whether the testimony was admitted or not.
What was the other evidence that, can you give us your best argument about why the identification didn't make a difference?
Well, we think that the identification didn't make a difference because there was corroborating evidence. So Jones's mother, Ms. Little, did state that she saw a Jeep at the scene of the crime.
But a different colored Jeep, right?
I think she just said a silver car or a silver truck, perhaps. So that was the same color as the Jeep that the defendant was found in. Similarly, Ms. Rosie Watkins was also at the scene, and she identified a Jeep being at the scene of the crime. In fact, I believe that a picture of the Jeep was admitted at trial, and she said, yes, this is the vehicle that I saw at the scene. In addition, Ms. Watkins did give a fairly accurate description of the driver, co-defendant Ramsey in this case, and Mr. Jones.
Because I have a question, though. Help me to understand this. If you're saying it wouldn't matter either way, then why do it?
I'm sorry?
If you're saying that this isn't going to matter either way, that this evidence isn't going to matter either direction, then why should we permit it to be done? This type of conduct.
Well, I think that, I'm not asking you necessarily to condone this type of conduct, but I'm saying that looking at the case law and the precedent in the state, that looking at the totality of the circumstances here, I think that, first of all, there was not a substantial likelihood of misidentification, and I think that this evidence was properly admitted. This is not a case where we had a show up, where the police brought the defendant to the witness and said, we've arrested this suspect. Is this the person you saw at the scene of the crime? I think that these show-ups, unfortunately, they have to take place in certain circumstances.
But do they have to take place here? He's in the police station. It's custodial. Is there an exit? I mean, what I'm trying to understand is why did this happen?
Well,
Help me to understand why this was done.
I think that Detective Rivard testified that there was an ongoing instantaneous investigation regarding a homicide. He said that the investigation was moving quickly due to the serious nature of the crime, and he wanted to determine whether the investigation was headed in the right direction. I think, importantly, the detective wanted to make a decision as far as whether or not the individuals who were detained.
Why not? What I'm trying to understand is why this was done in the first place. That's what I'm trying to understand. Because basically, when we read a decision, it's going to impact how this is going to be done in the future. And so, is there an exigency? I mean, is that the argument that, like, this is an ongoing, fast-paced investigation, so that is what constitutes an exigency? I mean, in the police station, what I'm trying to gather is that it just seems pretty basic and standard that you would have a traditional lineup. That's what I'm trying to understand is what was unique about this situation or circumstance that this was done in the first place?
I think that, again, the detectives were just trying to decide whether or not they were headed in the right direction, right? Somebody had been murdered, and they were trying to make a decision whether they've got the right suspects at the...
I understand. Thank you, counsel.
I didn't read your brief as really expanding or expounding on the Biggers factors. Can you give us your analysis of how those factors weigh in favor of the prosecution in this case?
Yeah, I would be happy to. And I did notice that the Court of Appeals didn't necessarily address each and every Biggers factor. And I think that's because some of them are not necessarily applicable, or some of them we didn't have enough information regarding at the trial level. So I believe that the first Biggers factor would be the opportunity for the witness to view the criminal at the time of the crime. Here, Mr. Jones did state that there's nothing obstructing his view. He was only 20 or 25 feet away from the shooting itself. So that definitely weighs in favor of the prosecution. The witness's degree of attention, he said that he was focused on the crime itself. He was focused on the shooting. He had nothing obstructing his view once again. He did state that he was focused on the driver at some point, but I think it's pretty clear that he saw the shooting itself, in that there was nothing else going on in that moment that he was focused on. He wasn't driving, he was in the back of the car witnessing this crime that was taking place. The accuracy of his prior description, I understand that Jones did, his identification of the shooter was definitely more similar to defendant Sammons than was his description of the driver, co-defendant Ramsey, but he did identify the shooter as being an African-American male with a shaved head. He stated that the driver was wearing black cargo pants and a white shirt. The defendant was arrested with a white shirt. I think he had jeans on, perhaps not black cargo pants, but in any event, his description was accurate in that way. We don't know.
Description being accurate as a black man in a t-shirt? I mean, in a white shirt?
Yeah, well, he said both defendants were African-American males with a white t-shirt.
Okay.
And I think that, you know, the chances that two African-American men would be pulled over in the Jeep that was described by 3 of the witnesses, I think the chances aren't that great. So looking also at the length of time between the crime and the confrontation, I think that Jones testified it was only about 4 hours from the time that the crime actually occurred until the time that he was brought to the jail for the show-up identification. And of course, we really don't have any evidence regarding the witness's level of certainty at the pretrial identification. Of course, at trial, he testified a little bit differently and said that the defendant had similar features to the shooter. But at the time that the identification was made, it sounds like he was unwavering in his response, that he identified defendant as the shooter.
What are we to make of of Jones's trial testimony?
I don't know the reasons why he, at trial, stated that he did not make an identification. I think that it's informative to look at his mother's testimony. Ms. Little testified that she didn't see anything, and she made a comment that they shoot witnesses. So I'm not sure if maybe that played a part in why he, at the preliminary examination at the trial stage, stated that he didn't make an identification at all. So I guess I don't have an idea why.
That, in your view, is unquestionably something that can be considered in the kind of super biggers context, can't it?
Yes, I agree. Unless the court has any further questions, I would just ask that you deny the defendant's application.
Thank you, counsel.
Thank you.
I'll be brief, Your Honors. I have to be. To answer the question of why was this done, the only explanation was given that it was an ongoing, fast-paced investigation. You can say that anytime you want. Every single investigation, when there's been a murder, is an ongoing, fast-paced investigation. But this wasn't that fast-paced. It's not like there was an active shooter out there. We're talking 4 to 5 hours had passed before they conducted this show-up procedure. 4 to 5 hours, plenty of time to arrange at least a photographic array, if not a live lineup. And they had the defendants in custody. Mr. Ramsey never had anyone identify him, and he's been in custody ever since. So there was really no legitimate reason given as to why they could not have done a proper lineup in this case. You know, we'd have to speculate, but yeah, I have some serious skepticisms about the motivations here. They knew that they had already interviewed Mr. Jones. They knew that the circumstances in which he had witnessed the crime, they knew that the descriptions didn't match by then. I think it was a gamble. I think
Counselor,
that's
can
why
you
they
address
called the prosecutor's office.
Would you address harmlessness? It sounds like your opposing counsel thinks there was plenty of other evidence that it didn't make a difference.
Again, Judge Jackson directed a verdict in favor of his co-defendant on exactly the same evidence, but for the lack of an identification witness. That's the only difference. That really should tell you something. And he was closer to that evidence than any of us in this courtroom. I wasn't at the trial, he was. That was his assessment. was this case is really weak, and the only reason that he denied that directed verdict for my client was because of the eyewitness identification testimony. So there's the answer. He would have directed a verdict in favor of my client. If there are no further questions, I will.
Well, as I assess the law in this case, it seems to me that looking at Supreme Court jurisprudence, in fact, you're correct that the show-up procedure is a dubious procedure, and it's viewed as being at least presumptively suggestive. But at the same time, the court's made clear that by looking at the Biggers factors and related considerations, there are circumstances in which the suggestiveness of the identification can nonetheless be overcome by circumstances suggesting that it's nonetheless reliable. Is that a fair way of understanding what the Supreme Court's given us here?
Yes, yes. I think that's, I agree that, in fact, the reliability is, again, it's a judicial screen that's a substitute for per se exclusion. If it weren't for that screen, you would per se exclude this. They decided not to have a per se exclusion and go through the reliability.
So we can stipulate that in the absence of some kind of exigence or emergency circumstances, this is not an ideal procedure. It shouldn't be adopted. But our starting point beyond that is to see just how much that process is overcome by the circumstances that attend the identification itself.
Correct. I hope, though, the court will take into account the lack of documentation in this case, because that is seriously prejudicial to the defendants. That's something that hasn't gotten a lot of ventilation. I think we need to pay some more attention to that.
Thank you, counsel. The case will be submitted. That concludes our call for today. We'll be back on the bench tomorrow morning at 9:30.